Welcome back to another edition of Between Two Fars. I'm Warneke Miller, and I am sitting here with Judge Reid Prouty, who is Vice Chairman of the Armed Services Board of Contract Appeals. I've really enjoyed talking with him and getting this insider look at the routine things we have to do every time we've got an Armed Services Board of Contract Appeals case. This is a big one, because I know anybody who's had a case has wrestled with this one. Summary judgment motions. When are they appropriate? When are they a waste of time? And when are they taken off the judge? Because whether or not you're going to invest your time in constructing a summary judgment motion may kind of hinge on that distinction. So what are your thoughts on summary judgment motions?
Thanks for asking, Warneke. There's a lot going on in summary judgment. I mean, first of all, it wasn't too long ago that the board explicitly disfavored motions for summary judgment. We actually said, we don't like them. We might rule on them, but we don't like them. And that was a while. That's in the past. That's no longer the case. Summary judgment is a legitimate tool for the quick and expeditious resolution of contract disputes. So when you've got a good summary judgment motion, by all means, please file it. But you have to ask yourself why you're filing it. I'll tell you, back in my advocacy days, I used to think that, hey, anytime I can get in front of the judge and tell him or her why I should win is a great way for me to tell my story. And if you tell your story often enough, well enough, they're going to be disposed to rule on you at the end of the day when you have the hearing, even if they don't grant your motion for summary judgment.
See, it's like brainwashing the judge. That's our technique.
Yeah, that's
tell
exactly.
your story often and loudly and file as many motions as you can.
I mean, you're an advocate, you believe you can actually do that. But it's not quite so simple. And I would tell you that only file a motion for summary judgment if you really think there aren't going to be materially disputed facts that should lead you to win the case for a lot of reasons. But let me first of all, we go backwards and tell you when is a good time to file a motion for summary judgment. What kinds of cases tend to be the ones where an MSJ is something you should file. And the ones that are pure contract interpretation are the classic example. Okay. We have cases like that. Did the contract require this or did it not? When the government required this, was this a breach of contract? How do you calculate how much the contractor gets paid for this issue? All kinds of things where you can actually look at the black and white letters of the contract and come to a determination of who should win. If you have a case like that, by all means, file a motion for summary judgment. By the way, if you have a case like that and the contract is legitimately unambiguous.
Okay, now we're talking about unicorns.
Yes. But for the most part, there are multiple times a year that we'll have cases across our desks where there's an unambiguous contract, and you can legitimately give a summary judgment in those cases. In that circumstance, why worry about having a hearing? Why have testimony when it really doesn't matter? You can go straight forward and go forward. So that would be a great case for summary judgment. And in fact, we even have a case or two that says a contract interpretation issue is a great issue for summary judgment because you really need it. Something about requires us to inquire about the reasonableness of somebody's conduct. That's not quite summary judgment material because you're always going to have quibbles around the edge. The kind of thing where your person says this is what the site conditions were, and the contractor's person says they were this and it's different. When you have contrasting evidence, even though your evidence, I'm sure, is much better than your opponent's, or so you think, or so you really truly believe, the rules for construing summary judgment are such that we're not going to grant you summary judgment. So should you go ahead and file a motion for summary judgment you don't think you're going to win as an opportunity to sort of get your information in front of the judge? No. Okay. I wouldn't quite go so far as Warneke did and say it's going to take off the judge. But I will say that there's a lot of work that goes into denying a motion for summary judgment, in large part because it is a decision on the merits, which requires the 3-judge process. The judge has to draft it and then has to have 2 other judges concur or not concur in it, and that takes a lot of effort and work. And in a case where they know they're just going to deny it, why would they go through that? Which will lead often in cases that might frustrate you, where the judge says, I've read your motion for summary judgment, and I'm going to defer ruling on it until the hearing. When the judge does that, she or he does not need to get the two other judges to concur with him. So it's a much simpler thing to do as far as the process goes, procedural-wise. Very easy for the judge to do. Very frustrating for you because you've already written that motion for summary judgment. But frankly, that is a risk you have when you've got a case that is obviously going to have disputed material facts. So I wouldn't waste my time if I were you on that matter. I would also say that if you're not sure if the facts are disputed or not, and yet you're giving us a 150-page motion for summary judgment, the fact that you need 150 pages might be a pretty good indicator that, there might be some facts in dispute here or somewhere. So another case where you might not necessarily want to file a motion for summary judgment, not to mention all the work you're going to go put into it. Spend that work getting yourself ready for the hearing. Those are the biggies. And again, in a proper case, bring a motion for summary judgment. In addition to pure contract interpretation, sometimes the statute of limitations, which is now a merits decision because the Federal Circuit in Sikorsky said it's no longer about jurisdiction, but it's about the merits. That too may be a subject for a motion for summary judgment. But again, sometimes statute of limitations issues are ones where there's a reasonableness, where they reasonably knew or should have known, in which case you might wind up being kicked back to the merits. But it's another opportunity for a motion for summary judgment. Thanks for asking.
Yes, and when you're thinking about whether or not you want to pursue a motion for summary judgment, it is a strategy decision on your part, you, the attorney who's handling the case. There's always benefit in going through the motions of thinking through how you would structure a summary judgment motion, because that may reveal to you some of the weaknesses in your case, or areas where you need more evidence, or areas where there are material disputes that you might not have otherwise realized. And there is no such thing as wasted effort for the litigation attorney. Any document you begin to construct can be used as the skeleton for documents that you will need to be filed, either pre or post hearing briefs or other argumentative documents that you're going to need during the course of your hearing. Likewise, it could be preparing you for ADR or for helping you understand your weaknesses so that you can talk to your client in terms of appropriate settlement. So keep in mind that just because you start down the path of writing a summary judgment motion doesn't mean you have to file it. And there's no wasted effort in beginning the process as you're getting a handle on your case and understanding what it is you're going to present to the Armed Services Board of Contract Appeals. Any other thoughts before we wrap up on this one?
I would just remind you that no judge ever got reversed by a Court of Appeals for denying a motion for summary judgment. And you should understand that that is certainly a consideration they have when determining whether or not there are material facts in dispute.
Yeah. All right. We just have been really enjoying talking with you on this, and we haven't even begun issues such as the Rule 4 file and other practice that leads up to litigation. So let's hang with Judge Prouty a little bit longer and talk some more about these very important issues. Join us again next time, Between Two FARs.